We have federal authority to detain individuals on this premises suspected
Agent, do you know where you are?
Ma'am, step aside. This is a federal
Let me
operation.
see a warrant.
Are you documented? Let me
I
see
am
your
a
ID.
sitting United States federal judge, and if you cannot produce a warrant in the next 10 seconds, you're all...
This venue is the kind of place that charges $400 a plate and has a dress code enforced before the elevator. Marble foyer, a string quartet on the mezzanine. The kind of private gala where the guest list is shorter than the waitstaff's NDA. The CCTV footage, 16 cameras, all cloud-backed, all time-stamped, all owned by a venue that has hosted 3 sitting senators and a Supreme Court justice in the last 2 years, captures everything in 4K. It's around 8:42 p.m. on a Friday. The room smells like real money and aged wine, and the particular self-satisfaction of people who believe the decisions they make in rooms like this are unquestionable. The doors open. Not because someone on the guest list arrived late, because 5 ICE agents in tactical vests walked through them. The room does not panic, and that is the phenomenon the CCTV body cam footage captures that no one in ICE's press office will be able to explain later. These are federal judges, senior attorneys, 2 state legislators, and a former U.S. attorney. They have spent their careers in rooms where authority walks in unannounced. They know what to do with it. They look up, assess, and wait, the way people wait when they are not afraid because they have never had reason to be. Lead agent Philip Copeland is first through the door, 34 years old, vest tight, the posture of a man who has rehearsed this entrance in his head and is currently performing it. Behind him, agents Jameel Ragsdale and Stanley Burke fan out toward the edges of the room. A 4th agent, John Homer, takes a position near the exit. Copeland raises his voice. "We have federal authority to detain individuals on this premises." Then a woman at the center table sets down her wine glass. She is 58 years old, in a floor-length gown that cost more than Copeland's monthly salary, and she has the particular stillness of someone who has spent 3 decades being the most prepared person in any situation. Judge Catherine Palmer. She had a standoff with the agents, the kind they weren't prepared for. The room goes very quiet. The string quartet on the mezzanine stops mid-phrase. The particular silence that follows has a texture, the held breath of 40 people watching a man walk towards something he cannot yet see. Judge Palmer looks at Agent Copeland the way you look at a car alarm that has been going off for 45 seconds. Patient, tired, certain it will stop eventually. Copeland picks up his radio and calls his supervisor, and what comes back over that radio 11 seconds later is the sound of a man beginning to understand the specific depth of the hole he is standing in. Before we go further, I need you to understand something oddly satisfying about this ICE true crime story that makes it different from every other one you've seen on this channel. Before we go any further, make sure to hit that subscribe button. This is not a story about an innocent person caught in a broken system. Catherine Palmer is a sitting federal judge who sat on the judicial panel that co-authored the very deportation act that handed ICE the authority they walked into that gala with. She helped write the law. She voted for the language that allowed federal agents to act on suspicion without a warrant. She believed, genuinely, on record, that the safeguards were sufficient. And then, on a Friday evening, in a $400 a plate venue, she became the person those safeguards were supposed to protect. What makes this a true story worth every minute of your time is not just that the ICE agents were wrong. They were, catastrophically, legally, career-endingly wrong. The CCTV body cam footage does not lie. The warrant they did not have does not become a warrant because the target turned out to be powerful enough to fight back. But the impossible discovery buried inside this case, a legal opinion that Catherine Palmer wrote herself, is going to reframe everything you think you know about who the villain of this story actually is. There's more than one reckoning coming. Stay with it. Catherine Palmer grew up in Baltimore's Upton neighborhood, the kind of zip code that teaches you early that the law and justice are related concepts, but not always the same thing. Her mother, Mirabelle Palmer, worked the early shift at a hospital laundry for 19 years and raised 3 children on the kind of income that makes pull-yourself-up advice sound like a punchline. Catherine got a full scholarship to Howard at 17, finished in 3 years, graduated top of her law class at Georgetown, and spent the first decade of her career as a public defender in federal court. Read that back. A public defender. The woman who would eventually co-author legislation expanding warrantless federal detention authority spent 10 years standing between vulnerable people and the full weight of government prosecution. She knew from the inside what it looked like when that weight came down on someone who couldn't absorb it. Which is what makes the legislation she signed on to at 54 so difficult to hold in a single hand. The Accelerated Immigration Enforcement Act, the bill her Judicial Advisory Panel formally endorsed, the bill whose language she helped shape in closed session over 14 months, gave ICE field agents the authority to detain individuals based on reasonable suspicion of undocumented status without obtaining a warrant prior to initial contact. The justification, in the committee language Palmer helped draft, was operational efficiency. The bill included what she and her colleagues described as robust procedural safeguards, review timelines, documentation requirements, supervisory sign-off protocols. Civil rights organizations called those safeguards cosmetic on the day the bill passed. They filed 3 separate legal challenges within a month. Palmer, in her capacity as a federal judge, was not a party to those challenges, but she was aware of them. She had read the briefs. She had her opinions, which she kept, as judges are required to, off the public record. What she had never done in 14 months of helping write that law was stand in a room and be the person it reached for. Now, Philip Copland. Copland had been with ICE's Chicago field office for 4 years, transferred from a regional border unit where his clearance numbers were strong and his questions were few. His supervisory file, pulled in full by the DOJ during post-raid investigation, showed 2 prior complaints, one for an unauthorized vehicle search, one for detaining a woman outside a Chicago hospital for 22 minutes based on a tip that was later confirmed as a neighbor dispute misdirected to a federal tip line. Both complaints had been reviewed by Field Supervisor Kenneth Wallace. Both had been marked resolved without formal proceeding. The pattern will sound familiar to anyone who follows ICE true crime cases closely because it is always the same pattern. A supervisor who measures performance by clearance rate and files complaints under the heading of within operational parameters until the day one of his agents walks into a room where the people inside have the resources and the standing to make within operational parameters the most expensive phrase in the field office's history. The tip that sent Copeland to the Gala came through an anonymous field intake line at 6:15 p.m. on the evening of the event. The tip described a private gathering at the venue address, alleged that a number of attendees were undocumented foreign nationals, and provided no supporting documentation of any kind. Standard operating procedure, the procedure that existed before the Accelerated Immigration Enforcement Act, would have required a warrant before entry into a private event of this nature. The Act's new language allowed for warrantless initial contact based on reasonable suspicion. Copeland decided a phone tip with no documentation constituted reasonable suspicion. He called Ragsdale and Burke. He did not call the venue. He did not call his legal division. He did not cross-reference the guest list, which was publicly filed with the venue's event permit and which contained, in alphabetical order, the name Catherine M. Palmer, Federal Judge, 7th Circuit. He just went. Let's go back 16 minutes. Before the entrance, before the vest and the voice and the whole theatrical production of federal authority walking through a door it had no legal business touching. Copeland's car is parked across the street from the venue. He and Ragsdale are in the front seats. The engine is running. The building in front of them has a valet stand, a red carpet runner, and a door attendant in a jacket that costs more than their combined daily per diem. These are not subtle signals. This is a venue that has been hosting the kind of people who make laws for decades, and it looks exactly like what it is. Ragsdale is the one who asks. The way you ask a question when you already half know the answer is going to be a problem. You confirmed the warrant status on this one? Copeland does not look at him. He is watching the door. We don't need one. Reasonable suspicion, new protocol. And that is it. That is the whole conversation, 4 seconds. Ragsdale doesn't push. Copeland doesn't elaborate. They get out of the car and walk toward the entrance like men who have already decided how this goes. What neither of them knew, what nobody in that vehicle knew, was that their own agency had already answered Ragsdale's question, in writing. 3 weeks earlier, a legal division memo, 1 page, sent directly to their supervisor, Kenneth Wallace, clarifying that the Act's reasonable suspicion provision covered street-level contacts and public spaces. Private, permitted event venues were explicitly excluded. Full Fourth Amendment protections, the memo said, remained in effect regardless of the Act's new language. Regardless. Wallace had read it. He forwarded it to his assistant with 4 words. "File this, thank you." And that is precisely where it went. Into a folder, into a system, into the specific bureaucratic quiet that turns a single-page memo into a grenade with a pin already pulled, sitting in a shared drive while 4 agents drive toward the most consequential mistake of their careers. Copeland was the right agent. He had just found the right room. Now here is the part that the ICE body cam footage captures that nobody in the agency's press office could later explain. When those doors opened and 4 tactical vests walked in, the room did not react the way rooms react in these situations. No scramble, no chairs pushed back, no hands in the air. The string quartet on the mezzanine stopped, but only because the first violinist, a woman who had been performing at federal judiciary events for 22 years, looked up, read the room in 3 seconds, and quietly set down her bow. She had seen enough. Everyone else just watched. The way you watch when you are not afraid. Because fear requires uncertainty, and every person in that room understood exactly what was happening and exactly how it was going to end. They had spent their careers in rooms where authority walks in uninvited. They knew what to do with it. They did nothing, which, as it turned out, was exactly the right move. Copeland reads the stillness as compliance. He mistakes it for control. This is his fatal miscalculation, the one running underneath every decision he makes in the next 90 seconds. He has walked into a space full of people who are not panicking because they outrank him. Not one of them. All of them, collectively. And several are already mentally composing the calls they are going to make the moment he leaves. Former U.S. Attorney Jeffrey Carraway is at the second table. He still has his wine. He leans toward the woman beside him, a senior 7th Circuit clerk named Quinn Biscayne, and says something just below camera range. Investigators later hired a lip reader to work the wide-angle CCTV footage. The confirmed transcript is 4 words. He has no idea. Carraway is not being cruel. He is being accurate. And here's the thing about Copeland that almost earns him a fraction of sympathy. He had off-ramps. Multiple. When Palmer asked for the warrant, he could have paused and radioed legal. When she identified herself, he could have stepped back and verified. Even after the 10-second ultimatum, 1 call to his own division would have surfaced the memo, the exclusion language, and the word regardless. And the worst outcome of his evening would have been an awkward retreat and a mildly embarrassing field report. He didn't make that call. Instead, he asked a sitting federal judge whether she was documented. The CCTV footage catches what happens to Palmer's expression in the half-second after that question lands. It does not change, and that is somehow more devastating than if it had. She gives him 10 seconds, which he uses to key his radio. His supervisor picks up mid-dinner and listens to 40 seconds of explanation before his response comes back in 4 words that will appear verbatim in 3 separate federal filings over the next 6 months. Copeland looks at the room one last time. Palmer has already picked up her own phone, calling her clerk and dictating calm, precise, unhurried case citation she has memorized because she is the one who wrote it. That citation is about to become the most consequential legal document in Philip Copeland's career. He just doesn't know it yet. The federal civil rights complaint was filed 11 days after the Gala raid by attorney Shauna Plummer, one of the sharpest civil rights litigators in the 7th Circuit, and, as it happened, a woman who had clerked for Catherine Palmer 9 years earlier.
The irony of Palmer's former clerk filing a complaint on her behalf was not lost on anyone, least of all Palmer, who approved the filing with the particular expression of a woman who has stopped being surprised by the shapes irony takes. The complaint named Copeland, Ragsdale, Burke, Kenneth Wallace, and the ICE field office. It cited warrantless entry into a private event venue, violation of Fourth Amendment protections in a permitted private space, and a supervisory failure to distribute a legal clarification memo that would have prevented the entire operation. ICE's legal defense team began preparing their response within a week. Standard procedure: find the case law, build the argument that the Act's reasonable suspicion provision covered the entry, establish that Copeland acted in good faith under the new statutory language. Their paralegal, a meticulous second year named Ana Hernandez, was pulling Seventh Circuit precedents on warrantless entry into private event spaces when she found it. Palmer v. Bureau of Alcohol, Tobacco, and Firearms, decided 18 months prior, written by Catherine M. Palmer. In it, Palmer had ruled, binding precedent, Seventh Circuit, that warrantless entry into a private permitted event venue by federal agents constituted an unlawful Fourth Amendment violation regardless of the agency's stated authority or the statutory language authorizing the action. The opinion included a passage, written in Palmer's characteristically precise prose, that read, "No legislative act, however broadly construed, extinguishes the constitutional protections of a private gathering held under lawful permit. The right of citizens to assemble without federal intrusion does not diminish because Congress has found it inconvenient."
Ana Hernandez printed it. She sat with it for a moment. Then she walked it to lead defense attorney Ricardo Wallace, no relation to the supervisor, and placed it on his desk without a word. He read it. He read it again. He picked up his coffee, realized it had gone cold at some earlier point in the morning, and put it back down. The case they had been planning to cite as their primary precedent had been partially overturned by Palmer's ruling. The statutory language they were going to use as a shield had been preemptively addressed in a binding Seventh Circuit opinion written by the woman they raided. Philip Copeland had walked into a gala and attempted to exercise authority that a federal judge had already ruled in writing that federal agents did not have in that context. 18 months before he put on his vest, before he sat outside in the car and told Ragsdale they did not need a warrant. The impossible discovery was not in a filing cabinet. It was in Westlaw. It had been there the whole time, publicly available, binding precedent, authored by Catherine Palmer. Ricardo Wallace called ICE's regional director at 11:40 a.m. The call lasted 7 minutes. The defense strategy that emerged from it was not a legal argument. It was a settlement inquiry.
Here is where this ICE true crime story gets genuinely complicated and genuinely honest, because the reckoning came for the agents. It came hard, and it came specifically, and it came with the kind of institutional weight that tends to arrive only when the person on the receiving end of the misconduct has the standing and the resources to make sure it does. That part of the story is real, and it matters, but it did not arrive alone. Copeland was terminated 6 weeks after the raid. The termination letter cited warrantless entry into a protected private venue, failure to verify statutory authority prior to operation, body cam activation failure, and, in language that his union representative later described as unusually direct for a federal termination document, a pattern of supervisory deference to a field commander who had been formally notified of the legal limitations of the act and had chosen not to distribute that notification to his agents. Ragsdale received a 90-day suspension and mandatory legal training, a consequence that civil rights advocates publicly described as inadequate, and that Shauna Plummer's legal filing noted with the specific dryness of someone who expected it and said so anyway. Burke, whose body cam footage was the most complete and whose conduct during the raid showed the fewest procedural violations, was formally counseled and reassigned. Kenneth Wallace was removed from supervisory authority, stripped of his field authorization, and referred to the DOJ's Office of Professional Responsibility. The memo he had received, filed, and failed to distribute became Exhibit A in the OPR referral, a single-page document that ended a supervisory career with the efficiency of a well-placed scalpel. He had been told. He had filed it. That was the whole case. The settlement arrived at 4 months. The figure was disclosed, $2.1 million, paid to the venue for reputational damages and to the Gala's attendees, several of whom had retained individual counsel for civil rights violations. ICE was required to implement mandatory venue classification protocols, mandatory legal memo distribution confirmation for all field agents, and a revised training module on the jurisdictional limits of the Accelerated Immigration Enforcement Act. The training module, as written, cited Palmer's Seventh Circuit opinion as its primary legal authority. They used her own ruling to train the agents who raided her.
Now, the other reckoning. Because 17 days after the settlement was announced, a coalition of civil rights organizations filed a separate legal challenge, one that had been in preparation for months, citing the raid on Palmer's Gala as the most publicly documented example of the act's unconstitutional reach. Their lead exhibit was the CCTV body cam footage from the venue. Their secondary exhibit was Palmer's own Seventh Circuit opinion. Their argument, delivered in a 94-page brief filed in the D.C. Circuit, was simple. If the act's reasonable suspicion provision was broad enough to send armed agents into a private gala attended by federal judges, it was broad enough to reach anyone. And if Catherine Palmer's own legal reasoning proved that entry unlawful, then the act itself required immediate judicial review. Palmer recused herself from any proceeding related to the challenge. She was required to. She issued a single public statement through her clerk's office that read, in its entirety, "The judicial process will determine the appropriate scope of the act. I have confidence in that process." 11 words. From a woman who built her career on precise language. 11 words was a choice. The D.C. Circuit accepted the challenge for review. The act, the one she helped write, was now on trial, partly because of what happened to her. Justice, in this story, is not a clean line. It is a circle that closes slowly and leaves marks on everyone inside it.
3 months after the raid, Catherine Palmer returned to the venue. Not for a gala, not for an event with a guest list and a dress code. She came on a Tuesday morning in a coat and flat shoes, at the invitation of the venue's general manager, a woman named Kiki Bruner, who had been the one to call the police the night the agents entered, and who had spent the intervening months fielding press inquiries and processing her own complicated feelings about what her building had been used to document. They walked the room together, the marble foyer, the mezzanine where the quartet had been playing, the table where Palmer had been sitting when the doors opened. Kiki had done something quietly, without announcement, in the weeks after the settlement. She had worked with a local civil rights legal clinic to post, in the venue's event contract addendum, distributed to every future booking, a 2-paragraph clause outlining the legal rights of private event attendees in the event of an unwarranted federal entry. It cited 2 cases. One was a standard Fourth Amendment precedent. The other was Palmer v. Bureau of Alcohol, Tobacco, and Firearms. Catherine read her own name in the venue contract and did not see anything for a moment. Then she said, "You spelled it right." Kiki laughed. It was the kind of laugh that releases something. Outside, the city moved the way cities do, indifferent, continuous, utterly unbothered by the specific weight of what had happened inside this building on a Friday night. The federal challenge to the act was still working its way through the D.C. Circuit. The agents' terminations were still being appealed through their union. The memo that Wallace had filed and not distributed was still Exhibit A in an OPR file that had not been closed. Palmer buttoned her coat on the sidewalk. She had a hearing at 2 o'clock, an immigration case, as it happened, under the very act whose future was now in legal question. She had recused herself from the challenge. She had not recused herself from doing her job. She walked toward the courthouse. The city kept moving around her. The law she helped build was being tested by the thing that happened to her. She was still the one who had to show up and apply it.
I'm going to ask you to sit with this one differently than you usually do after a story on this channel, because this is not a story with a clean hero. Catherine Palmer was wronged, genuinely, legally, on camera, without a warrant. Philip Copeland and his team had no business in that room, and they will spend the rest of their careers with that documented fact attached to their names. That is real. But the act that sent them through that door, she helped write it. The language that Copeland cited when he told Ragsdale they did not need a warrant, she sat in the room where it was drafted. The people who had been saying for 2 years that those safeguards were not sufficient, they were right before the gala. They were just easier to ignore when the people being reached for didn't have 16 cameras and a former U.S. attorney at the next table. That is the comment I want you to leave. Not about the agents, about the law. Don't forget to hit the subscribe button and share this with someone who thinks accountability only moves in one direction.